Well, hello, ladies and gentlemen, boys and girls. Harry Brailsford coming to you live from Microsoft Ignite. I'm surrounded by 30,000 of my best friends. Not really. It's a slightly different crowd than SMB Nation is used to. It's the IT pro crowd. Probably several hundred vendors out on the floor, 30,000 attendees. I'm focused on Power BI topics this week here in Orlando, and I'm attending as an analyst and press. So fortunately, I'm allowed to use one of the press rooms for today's webinar. We'll get to that in just a moment. I want to thank our sponsors, Solar Winds and Cinex. As you know, it makes the world go round that we have Solar Winds and Cinex graciously underwriting our community efforts to bring you academic content, and today really fits that bill in terms of the topic on the MSP legal matters, for lack of a better word. Before we get to Ben Yarborough, I want to remind you to use the questions feature to ask your questions. I'll be citing those out. And check out the handout section. And again, today is a darn good day to ask questions. I don't know that Ben, he'll be able to speak to this. I don't know if he can give true legal advice to you, but he can certainly speak towards MSP legal matters. So I'll let Ben clarify that. But Ben, let me kind of introduce you, and then you'll probably do a better job. But folks, you may remember Yarborough, first and foremost, the Calyptic security company that has a firewall that I like to think of was community built. So he engaged with the MVPs some time ago, the Microsoft SBS MVPs, and really had them help. They really helped with the product design and engineering and the marketing and so on. And so, like so many of us, Ben and Calyptics are here yesterday, here today, and here tomorrow. And then, Ben, why don't you get it from there? I think a lot of people do know you from Calyptics, but a lot of people don't know you're a practicing lawyer. What does that mean? And then let's jump into your slide deck, sir.
No, that's great, Harry. First, I want to thank you very much for you and Jenny inviting me and Calyptics to share our perspective and insight. And yeah, it's been over 10 years. It's hard to believe that we first got to know each other back in '07 and really cultivated relationships with many of the Microsoft MVP partners and learned about Small Business Server and the challenges they faced back then. And to today, we continue to thrive in that partner ecosystem, focusing on designing and working with our solution to solve their problems as small business IT professionals. But it's interesting, coming up on 25 years as a lawyer. Went to Davidson College right outside of Charlotte here in North Carolina, and then to University of Virginia to get my law degree. I practiced law for 20 years and have gradually rolled into technology and really seen the birth of cyber law as a whole new practice. And it is the early days of cyber law, and it's interesting to me that as we take our twins, boy and girl twins, to look at colleges, they talk about training our kids for jobs that don't exist today. And then I turn around and look in the mirror, and I guess I'm doing a job that didn't exist, when I went to college. So, and I'm sure many of our IT partners and folks that we work with, they're responsible for things that didn't exist when they started. So they're having to learn on the fly. So today, I wanted to share really from some content more about the legal perspective on cyber law, cybersecurity, and some of the traps and challenges that our partners and other MSPs face. There's no doubt that the risks are growing. We're going to touch on the reality of those risks and what's coming down the pipe. We're going to look at the actual legal threats from a legal claim perspective. How might somebody come after you? And we're going to talk about things you can do to protect your company, your assets, the way you pay your employees. A lot of regulations out there. I don't think in the future that an IT professional can provide services to their clients without being regulation savvy and aware. It's an environment that you're going to be in, and we just have to deal with it. And lastly, I want to talk a little bit about cyber insurance. It's a massively accelerating industry. It's very tricky, very dangerous, a lot of opportunities. I would like to premise this conversation first and foremost with this is not legal advice. These are my own opinions. They're not Calyptic's. I hope you get some valuable insight. That is a value we hold dear at Calyptic's, and that is delivering value to our partners. It happens I know a little about the topic, so it's an opportunity to share. The second is this is going to be somewhat legal focused. That means bedside manner, relationship, trust, integrity, culture, those aspects of the relationship which IT partners have, hold, and really are custody of with their clients. I'm going to set that aside. A lot of these legal risks and issues can be reduced, minimized with a open, transparent culture that communicates clearly with your customers, that establishes realistic expectations, that doesn't hide the truth, that does the best you can. Your customers appreciate that and they expect that. If the Pentagon cannot be protected 100%, there is no client in the world that thinks you can protect them 100%. So you need to create that culture of openness and transparency. And at the end of the day, that can mitigate most of your risk. Notwithstanding that, let's talk about the issues.
Hey, Ben, let me ask you a question about your disclaimer, if you don't mind. That if I'm correct, attorneys are licensed at the state level by the bar. You're in, I believe, North Carolina.
That's correct.
And I understand your generic disclaimer, but there's also maybe a disclaimer that you would not be. It would not necessarily be permissible for you to engage with somebody in the state of Colorado or the state of Washington.
No, that's right. There's some claims and some issues, whether it's contract, liquidated, very technical things that are very state specific. And so those would definitely be appropriate for your local counsel. And it's just, people need guidance. And the other piece is that lawyers have to be careful of is when I share some information, does that make the recipient of that information my legal client, which then invokes duties and responsibilities, and I don't want that this communication to create that kind of situation. But I don't think anybody would expect that, so I think it's good.
Okay, and Ben, if you could double check your camera, I'm not seeing your camera. Jenny, maybe you could do a sanity check if Ben's coming through, and it could just vary. There's Ben.
Oh, okay, so it has to be on my screen for you guys to see it.
Yeah, okay. All right, let's rock. We're on the growing risk of MSPs. Let's rock and roll.
It may flick off, though. I may lose it. For me to be able to control my slide deck, I'm going to lose the camera.
No problem. No problem.
So really, the vulnerabilities are there. They're in equipment. The FBI continues to, when we first started, everybody thought a Linux router was indefensible, that you didn't have to update it, that there were no problems. That myth has been dismissed entirely now with the targeted focus on firewalls, routers, Linux, all the different vulnerabilities there. And so, the level of non-compliance is very high. And in addition, you look at the regulatory framework, there's been data breach notification laws, which lawyers have been jumping up and down about. And now there's the escalation of the PCI credit card requirements now for multi-factor authentication, and those requirements continue to escalate, as they should. And most recently, we have the European GDPR, which was promulgated primarily to target large data aggregators. We know who those are. But the reality is it's hitting small businesses likewise. And so there's a lot of confusion and concern around that. More specifically, the whole enforcement landscape is the wild, wild west. The FTC has weighed in now and made it clear that they have authority to establish in court against any commercial enterprise failure to maintain reasonable and appropriate data security. FTC sued Wyndham Hotel for its failure to secure their networks for customer data. And they basically, after lots of appeals and lots of motions and money and the like, they eventually settled and they issued an opinion that FTC has the authority and they can decide what's reasonable. In addition, states' attorney generals are weighing in on it. The SEC is weighing in on it. The OCR, of course, is weighing on it from HIPAA, and not to mention contractual obligations and industry like the PCI. And even just recently, I think many of in the industry are familiar with the NIST standards. 853 is about a 6-inch document, about 600 pages of detailed specification and regulations that outline the protection of confidential information in federal systems. Several years ago, they promulgated a extracted version of that for non-classified information in non-federal systems, 800-171. That makes it about a 2-inch book. That data, those restrictions are applied to DFARS, which is the Defense Federal Acquisition Regulation. So if you provide services as a DoD contractor or subcontractor, you are now, as of January 1, 18, required to comply with NIST 800-171 as it relates to the controlled information around your services for your DoD contract.
Hey, Ben.
Yes.
Yeah, if you don't mind, and are you comfortable with me stepping in when appropriate with the question?
Oh, absolutely. Absolutely.
Okay, we had David Seavies asking, you had a date on the prior slide about the PCI DSS multi-factor authentication. Could you pop back to that prior slide just a sec and with the PCI thing? And he can, there we go, February 1st, 2018. Cool.
Yeah, so, PCI over the years has continued to escalate their requirements. And so this is an example of one of those additional escalated requirements. And so that's going to depend really you got to remember, PCI is all about the cardholder data and the scope of network as defined by where does the cardholder data get entered, where is it transmitted to, and so forth. So that particular aspect needs to be considered in that light. And, frankly, to provide more specific detail on that, I need to pull the regs.
Yeah.
But I think the purpose here is, if you play in that game of retail clients that accept credit cards, you've got to understand where the data gets entered, where it gets transmitted, and how that infrastructure is established. And so you can't go to sleep on the regs.
Thank you. Okay.
So more specifically, and if there's specific questions like that get really into the nitty gritty, we can pull that together and respond. If we go into nitty gritty, we won't get through the deck. But it's a very valid question, so I don't want to dismiss it. It's just need to kind of move forward. But on the one that's got me really, my interest peaked is most recently, our president signed into law the NIST Small Business Cybersecurity Act. And the interesting piece of that is when you look at the way the federal government has evolved the cybersecurity framework implemented by 853 to then 800-171, they are beginning to frame up a set of reasonable, expected technical implementations there. And so NIST is to promulgate clear and concise resources. But while they have put out resources, I expect, I don't know this for a fact, but I would hope that they would take the 800-171 and even narrow it further down to maybe, instead of an inch, maybe a half an inch of guidelines, so that they can establish a framework. What's interesting, it's supposed to be a resource, not a requirement, and it's not intended to establish liability. Notwithstanding that, you have to remember private parties can contract for anything. So if you're a small business as a supplier to a larger organization, those larger organizations are groping to establish expectations and responsibilities for small businesses as supply chain providers. And so I would expect that any guidance there to become an opportunity to be incorporated by contract. So you got the regs on the rise, you got enforcement on the rise. Typically, that's dollars, that's lawsuits, that's OCR under HIPAA, that's FTC, That's private civil litigation, class actions. There are a couple of cases that I found really interesting in reviewing the materials. The first one is a legal malpractice claim for a business email compromise in which the law firm received $1.9 million in connection with a real estate transaction. Guess what? They got intermittent directions over email to change the wire instructions. They didn't think anything about it. They sent the wire, bada boom, bada bang, it went to the wrong people. So you can imagine when people lose real money, they fight about it. So the difficulty here for the law firm is that's not really a covered legal malpractice claim. That's a technical mess up, right? So there's not a pot of money for the lawyer to point to cover that problem. So they've got a real issue. The second case is a massive case that's under litigation right now. And any of you that have been to a doctor might have heard or have medical clients, a company called Allscripts. Allscripts is a public company, very large. They provide a cloud-based electronic data management system for keeping patient records, prescribing medications, and the like. Well, it turns out that Allscripts got infected with ransomware. And so a whole bunch of their customers, orthopedic practices, and this one particular one in Florida, couldn't operate their business for several days. They lost money. They had to reschedule appointments. They couldn't practice. They had expenses. They had losses. So in this case, these folks are trying to recover their lost business expenses, operations, get back up to and so they are suing Allscripts. Right now, since January, when the case was filed by a very credible law firm from Jacksonville, Florida, with 5 different alleged claims: contract, negligence, a whole host of others, some unfair and deceptive trade practices, which basically are fraud-like claims, and they filed 85 different documents through like last week. And the firms that we're talking about are massive law firms spending lots of money. So this is not the government coming after somebody. These are private businesses going after each other because they didn't live up to the bargain. Now, this third lawsuit is even more interesting to me because there's no actual damage that occurred here. It really stems from a client of a large law firm that put a $30,000 retainer with a big law firm in Chicago to help them create a Bitcoin type business, okay? Somewhere that things probably went bad. Now, I went back to that earlier conversation about maintaining a good relationship with your clients. I think this didn't work out too well for the client. And he found out that the law firm was using a vulnerable email platform, a vulnerable JBoss data entry platform for time records. Their VPN platform they were using to connect to the environment was not maintained. And so they literally sued the law firm on behalf of themselves and attempted to get a class action for all clients of the law firm to seek an injunction to get a actual forensic investigation to determine if their data had been compromised. There was no known breach. It's just, hey, we know you're not securing our data. We're worried about it. At the end of the day, they settled, but it raised a claim. I mean, the fact that the law firm was holding, using a vulnerable system created the basis of a contract and other type of claims against the client. So the point is, it's happening. So when you look at what's happening and the type of claims that are arising, really, what are they? And I think, go back to Law School 101, and the most common one is a breach of contract. So you go back to the Allscripts case, somebody has licensed the Allscripts platform, they're paying them money. So wait a minute, you're not doing your job of keeping a secure system up to, that I can use. I'm now relying on you. So that's a claim in contract. Then there's a negligence claim and a regulatory enforcement. So those are sort of the three prongs. So again, for a contract claim, that typically comes from either not really clearly defining what your contractual responsibilities are, or a very clear breach of your responsibility. You know, if you're supposed to pay $1,000 and you don't pay $1,000, that's an easily identifiable breach. If you're supposed to do a good job, well, what is a good job? Yeah. If you're supposed to be in charge of IT, what does that really mean?
Yep.
So if you don't clearly define it, then that has the potential to lead to a contract claim. So, and the other is, on the flip side, having an engagement where you limit what you're responsible for. And we'll get into some details about that. So that strong agreement, clear communication is key. Negligence, on the other hand, is a claim that arises under what's called common law, and that's different from contract law. Common law is a claim based on judges deciding that somebody can have a claim. Those include negligence, they include misrepresentation, they include fraud, and those types of claims. Typically, negligence would be here. Somebody is not living up to their responsibility. They have a duty to the client. You think about a doctor. A doctor has a duty, a standard of care to deliver good, reasonably acceptable standard of care for health care. If they fail to do that, then they breach their duty. And if that failure is the proximate cause of damages to the client or customer or patient, then they may have a claim. So you can generally avoid that with, the best way is to meet your standard, understanding what the standard is. The third one comes from a regulatory enforcement, and typically from a regulator, which we're familiar with, HIPAA, the OCR, or DSS, PCI, and it's really not fitting within that box and ignoring those obligations. And deciding affirmatively whether or not you are going to do business in that world or you are not going to do it, and behave accordingly. The way to avoid that, really, and we'll get into more specifics, is to make sure you understand what requirements your clients have. And to the extent they do have requirements, go into that with your eyes wide open. So how do you do it? And then again, notwithstanding the importance of maintaining a healthy, trusting, caring relationship with your client, from a legal perspective, you need a really good contract. It's clear.
Yeah. And what I would offer is exactly that. I in another month and a half, SMB Nation will be starting its 20th year in business, and I'll tell you this: I certainly, I try to have great client relationships. I think I'm a people person, but I can, and that will bail you out of trouble, right? So I'm gonna make a couple points. Number one, a strong client relationship will bail you out of trouble because you have a friendship, a relationship, and there's maybe a little bit of forgiveness. When the relationship, for whatever reason, is not strong, and it can be a couple things, Ben. I mean, I'm talking the Great Recession, where all good people, but just under a lot of stress, and it changed the nature of the friendship. So nobody did anything wrong. It's just the nature of the friendship changed. And my experience is when you kind of go back to the statement of work or the contract or the T's and I's of the written word, you're already in trouble. And again, I'm just trying to think that field.
I think that's exactly right. I mean, I think a very good friend of mine, I started with Calyptics and trying to find customers and help and do business. He shared with me as a young man who his family owns a business that's over 100 years old, and they're very large here in Charlotte. He said, Ben, you just got to remember, you got to find people that you want to do business with, and they want to do business with you. Yeah. And when that equation changes, you begin to get into sort of a potential point of trouble. And that's where, choosing your clients and knowing that relationship is important, because cybersecurity introduces a lot of unknown risk. And for a small business IT professional to be the backstop for that risk is not reasonable in any regard. And so, but that can happen when things don't work out, when people sour, or like you said, when the economic environment changes. And let's give an example. Let's say you work with a small law firm that does all their legal closings for XYZ mortgage company, right? That's where they get 80% of their business. Well, if the mortgage company comes down, is pushing down some changes or finds out there's a technology problem with that law firm, if you as an IT provider get pushed on the outside of that or don't collaborate constructively, it could go bad very quickly. And
Yep.
so so that aspect is important. But at the end of the day, I mean, this is a legal conversation. So really, when you go to the contract, if you have to go to the contract, you want to be solid, okay? And that's just, that is what it is. You want them to look at the contract and say, yeah, I guess it's more important for you to help me figure this out and solve the problem than to look at you, Mr. IT provider, as a deep pocket, right?
Yeah.
So how do you do that? So I don't know if we're on time, Harry, but we have some great sponsors.
Ben, we're exactly on time. It's 12:30 Pacific. So why don't we take, Ben, catch your breath, top off your water, and Jenny, if you want to go ahead and queue up the Cynics video. So folks, if you came in late, we're talking MSP legal topics. We're underwritten by Cynics and SolarWinds. And please, if you're on the phone, the video will come over your speaker. Thank you. And I do see some questions we'll answer on the other side. Well, come back in. Here I am. And Jenny, I believe we're going to have a conversation with Colby. Colby, are you with us today, my friend?
I am. How are you doing?
Good, good. Hey, Colby, I have a specific question. We've chatted in the past, and Cynics is a known quantity and respected in the SMB Nation community, and we can certainly have that conversation again. But
Yeah.
I'd rather talk about, and we do have a poll question up, folks. Do you currently have a Microsoft Cloud practice? Go ahead and answer that while Colby and I talk. Colby, a conference that I don't think gets enough attention since we're in the heart of the fall conference season. If you can see my video, and I'm at Microsoft Ignite in Orlando and in
Yeah.
a press room. But you have a conference in November, and I believe it's in a very pleasant area. I'm going to say sort of Southern California, Cinex Varnex. I don't think enough of our crowd knows about your conference. What is Cinex Varnex?
Yeah, so actually we have two conferences going on right about the same time in
Okay.
November. Both of them are in the same location. The first one is actually our Cloud Catalyst conference. It's going to be taking place at the same literally right before our Varnex conference.
Okay.
Cloud Catalyst is going to be really about MSP practices who are getting into the cloud. Varnex is really for our VARs, for any of our value-added resellers. It's a time for them to get together, learn about what Cinex is doing, what we're trying to do to help them, and continue to grow their business.
And this is and I'm shooting on the fly, but is it from Palm Springs, California?
Yeah.
It's somewhere down
Yep.
south.
You're correct. Palm Springs, California.
Okay, and I'm assuming also, given the nature of the SMB Nation community, this is reasonably priced for people to attend. It's not like a hardcore enterprise conference that I'm at.
No, absolutely not. We try to price everything very reasonably. I mean, our bread and butter is SMB. That's what we do best. That's where we really have our biggest focus. So we try to make sure that it's perfect for our MSPs who can make sure they can attend.
Yeah, and then maybe the final question is, and again, I'm trying to tee up my own presence at your conference. I'm working on the logistics. I have not gone before. Colby, I'm sitting at a conference with 30,000 attendees. Let me tell you, it's like walking around for 3 days at a NFL. It's like an NFL football stadium for 3 days, right?
Yeah, absolutely.
I wouldn't say there's a high degree of intimacy. I'm assuming your conferences last. Do you have a sense? Are you 200, 300, 400? I mean, personally, I like smaller conferences. I'm just curious where you fit. Oh, in general, what's the size of your conference?
Yep, between that 200 to 500 range is actually perfect. Depending on, as we do several Varnex events throughout the year, and depending on the location, depending on how many sign up, but it's generally right between that range. It's perfect. We have a great intimate setting. You're going to be able to talk to people who are over any of our mini vendor lines. Just a great time to meet our team, get to know what we can do, what we can offer.
Yeah, and then probably won't have, doggone it. I'll end on this, my friend. Is that my darn left foot is hurting from walking around. So I wake up in the morning and I'm reminded I'm not 22 years old anymore.
Yeah, I understand. I was at Microsoft Inspire a few months ago, and I completely understand walking around with tens of thousands of people. It's a mess.
Yeah, yeah. Well, Colby, is there anything else you'd like to add, my friend? Jenny, go ahead and close the poll and start to transition to Ben. But Colby, any parting thoughts? Maybe you had one or two talking points. I just wanted to talk about your November conferences.
Yeah, I could just mention a little bit. So, I mean, the poll is about asking if you have a Microsoft Cloud practice. If you do, we'd love to help. I work on the Microsoft Cloud team, so you've got people like me who can help. We're experts in what we do. Just lean on us. You don't have to know it all. Our job is to help make sure you can navigate those Microsoft waters, and those are deep waters.
There we go. All right. Well, we'll hope to see you in November. And thank you, Colby. And Jenny, give the talking stick back to Ben. I have some questions from Luis Swall, David Seavey, and Ken Schaefer. Ken, I can knock this out real quick. Ken, we will have a recorded version of the webinar posted. Give us about 24 hours and it'll be up on the YouTube channel. You'll get the private link. Luis Swall, I'm going to hold your question. There's a lot to unpack in there. Let's get a little bit deeper. And then David Seavey, let's go ahead and take this one, Ben. So David says, this one's more of a direct hit. David says, if you have to go to a contract, you said if you have to go to a contract, and that could have been myself or you, Ben, are you suggesting the best choice is not to have a contract unless you have to? Ben, I'll let you answer.
No. What I'm talking about is in the resolution of a dispute or a problem with a customer, when the parties go, retreat to their corners and start looking at the terms and conditions of the engagement, you are in trouble. Yeah. And so if you have a no agreement then you're in deep trouble because you have no clear terms and conditions and clear understanding of your responsibility. If you have a poor agreement, you may be in trouble. If you have a rock solid agreement, you're better off, but you're still headed down into a cat fight. And when cats fight, nobody wins. And, you know, the lawyers make money. So, but that's not what I do anymore. When I say, you know, you don't want to go to the contract, that means you don't want to solve the dispute by looking specifically, you know, negotiating the requirements under the contract.
Amen, brother. There's country western songs about it's cheaper to keep her, or if we said cheaper to keep him. So, Ben, I think you have the live screen. There you go. I'm seeing a baby.
There we go.
Go ahead.
Perfect. Yeah, so I thought this is our head of marketing, Adam, who helped put these slides together. They're great. He makes my job really easy. I like to share, and he likes to simplify it and keep me on task, which is great. But he just recently had a young child. I guess they all start out as young, and I thought this was his son, but it's not. But really, when you think about it, you guys have all created your managed service practice over the years, one step at a time, one client at a time. You know, finding the right tools, finding the right service partners, finding the right distributors, changing technologies as needed, and it's tough. And so you got to protect that. Your clients, you know, your good clients depend on you. Your employees depend on you. Frankly, your service and vendor partners depend on you. And so it's a totally symbiotic relationship. So from a legal perspective, what I've always suggested is you really have two core documents. One is a form agreement. It's the same for every client. And the second one is your statement of work. You can't afford to have an agreement that changes from client to client because lawyers cost twice, 3, 4 times as much as you do. And so, you know, by the time you've negotiated a new legal document, you're in trouble, you know, from an expense standpoint. So if you can establish a good form document that essentially sets a baseline that's clear, that's reasonable, that allocates the risk largely at the end of the day to the client, then you have a starting point to have a discussion to address any unique issues, concerns, particularities in a statement of work. And so, you know, that form agreement is like your foundation. It sets, you know, makes certain representations in warranties, covenants or agreements, you know, limits of liability. And ultimately, it should force the client to disclose all their special requirements. You know, if they have the keys to the kingdom and they don't tell you about it, and you only charge them $1,000 a month, but they've got the Coca-Cola formula. I grew up where Coca-Cola was invented by Dr. Pemberton in a pharmacy in Columbus, Georgia. Of course, everybody now knows Atlanta, quote unquote, is the birthplace of Coca-Cola, but it's not. It's Columbus. But that formula is written on paper and it's held in a vault at SunTrust Bank in Atlanta. That's the only copy of it. SunTrust knows they are the custodian of that asset, and I can assure you that the methodologies and the controls around securing that lockbox for Coca-Cola is really, really, really tight, right?
Yep.
And they know the value of that, and they charge an appropriate fee. You know, another example is if you ship a letter pack to Harry for something, some information, you know, FedEx covers it for $100. But if it happens to be, you know, a stack of Benjamins, maybe he won a bet and you're paying him off 10 grand and you put it in the FedEx pack and you ship it to him. If it gets lost, guess what? You only get $100 unless you tell FedEx that it's a $10,000 package and they'll charge you. So what really you're doing is that you don't look at the form agreement as a gotcha. Don't look at it as I'm going to one up you, I'm going to hide things. It's really, you're trying to smoke out the needs of the client. And if you're willing to address them, then you can. If you can't, you can't. But it creates a communication that allows you to decide. So when you look at the agreement, now again, I'm just focusing on a couple of key terms that might relate or be implicated in connection with a cybersecurity breach. So there are a lot of provisions. There's the miscellaneous provision. There's the fee provision. There's the, a lot of reps. There are a lot of different provisions. But the real keys here, there are a couple. One are customer obligations or covenants or agreements. What do they affirmatively decide they have to do? And it's an interesting, you want them to pay you timely. You want them to do their things. Then you've got the company obligations. I'm going to go into these. I don't want to hit all the details now, but then the company obligations. What are the covenants of the IT provider, the MSP? What are you going to disclaim? This is kind of boilerplate, but you clearly disclaim warranties. There's some ways to limit liability, and then there's a direct way to transfer some risk on various things. So on customer covenants or obligations, you want to require them expressly to notify you of any unique needs, regulatory issues. I mean, it needs to be clear. You got to tell me that you're a retailer subject to PCI DSS, or you have a contract with a third tier DoD subcontractor where you get copies of plans for waste, the waste production, the waste disposal facility at a military base. You may not think anything about that, but that information is restricted. That subjects that customer to DFARS, as I mentioned, the NIST guidelines. And if they don't tell you about it, it should be their response. I mean, they have to tell you. Additionally, it needs to be clear that they need to indemnify you, which means they hold you harmless. They reimburse you for legal fees, for out-of-pocket expenses, or actual damages if they don't do their job. And so, and ultimately, they have some very key obligations there. They're broad and they're very all-encompassing. And that sounds unfair, but remember, you're trying to smoke out what's important to them. On the flip side, as the MSP, you need to establish a clear, reasonable standard of care for a small business IT provider. Best efforts, it needs to exclude responsibility for anything you don't do. If you don't do network traffic management, if you don't do, real-time monitoring of IDS, IPS systems, if you don't do, immediate reviewing of different logs, or, if you only do what's specified in your statement of work, that's the other way to put it. We don't do anything in what's expressly set out on our statement of work. And then you provide a real detailed list of what you do. And it's conditioned by reasonable best efforts. A little higher standard might be commercially reasonable best efforts. But you can even get more specific if you wish. But you want to be careful there, because that's kind of, at the end of the day, the standard that's going to kind of hold you accountable. You can't do nothing. I mean, you can't hire a bunch of idiots to do, to run your business. You can't recklessly disregard, an issue. So you need to be reasonable there, but just, you got to be careful. That's where your lawyer can help you. There's another thing you have to be careful about in B2B transactions, and those are warranties. There are different specific warranties that you learn about in law school that operate under the Uniform Commercial Code that's in every state for sales or services, like warranty for fitness of a particular purpose, warranty for merchantability, express warranties, implied warranties. And there's good boilerplate that lawyers use to disclaim all of those. So you are not a guarantor of IT services, and you need to make that clear. That's what the warranty does.
Well, Ben,
disclaimer.
Let's talk about that for a sec. I've been in more than one conversation in my career about if software companies were the same as the automobile industry. So the automobile industry has frequent recalls, right? Like some part fails, and
right.
you have to go in and get it changed. And if the software industry had to, operate under the same standards as Ford Motor or GM, it'd be a whole different game. I'm trying to formulate a question. Maybe you can bring it together for me.
Well, yeah. Let me share with you a perspective as a lawyer, as a software vendor, essentially, and I've got lots of ideas and lots of theories and lots of papers in my head, but the allocation of liability to organizations for delivering a safe product or service is a real issue, and it's a very difficult issue in software. In automobiles, over the years, it's called tort or product defect litigation, or it happens for drug manufacturers. It happens to automobile manufacturers. They get sued when their product is dangerous. So why doesn't that happen to IT vendors?
Yep.
And there are a lot of reasons. Could it happen? Yeah. If you write code that, in my opinion, this is Ben's personal opinion, if somebody puts out software that has holes in it, knowingly, recklessly disregards, it creates exposure that will lead to clear losses of the customers, and they put that out there, should they be responsible for that? Maybe so. It's a complex question, a complex issue. I think the legal world is probably moving there, but being able to prove it and have damages that match up to it are difficult, because there are a lot of intervening elements to it. But I do see that world colliding, if that helps answer your thought.
Yeah, that's my question. Please continue.
Yeah. So that's a topic in and of itself. Yeah. But one of the ways that's done, though, if you look at a software license, an end user license agreement, I mean, somebody's licensing you software for $30 a month. That if you buy Excel, think about this: you pay for Excel or Office 365. You can make billions of dollars using Excel. And I've sold you software for $10 a month now. Now, they used to sell it to you once and you could use it forever, but then they realized that there's ongoing cost for Microsoft to maintain it, update it. So now they've actually gone to a service model, and I believe it's largely to match their cost to the reality, is that the obligation a software vendor has is to update, maintain the productivity and security of the code. But a hedge fund might lose $1 billion with a macro vulnerability in an Excel spreadsheet.
Yep.
An accountant might lose $100, So if they sell you that software for $100 or $10 a month, what's who should take the risk? And, one way they limit their liability is in their end user license agreement, just like you should do in your MSP services agreement, is have some express provisions that limit your liability. And there's sort of two approaches to that. One is, excluding things that you clearly should not be responsible for no matter what. Incidental or indirect damages. Those are types of consequences that might flow from a problem. Liability related to third-party software. So if the IT provider, should they be responsible for the ransomware that hit Allscripts? No. Should they be responsible for, AWS going down? Should they be? No. So, should they be responsible for a problem at Calyptics? No. An MSP professional shouldn't own that risk. So there are things you should exclude. Hardware fails. Software has vulnerability. And there are hackers out there.
Yep.
You can't insure against bad people. It's not your job. So you should expressly exclude those types of damages that might arise. Now, damages, there's lots of types of damages. There's the lost profits. There's the incidental costs. There's things like that. And we can talk more about that in the cyber coverage. But you got to exclude all of that. The other very carefully created approach, which will vary by state and may not be available in all states, is using a provision called a liquidated damages provision. A liquidated damages provision is when it says, hey, you know what, if there's a breach here, the most I'm responsible for is the greater or lesser of 6 months of what you paid me or $5,000. So what you're doing is in order to create a liquidated damages provision in North Carolina, the parties have to recognize that they cannot anticipate the likely consequences of a breach. It's like if there were a breach of this agreement, we have no idea what damages might flow. And therefore, in order for both parties to enter into it, we're willing and it's reasonable to put a limit on them. And that limit is some reasonable amount. If it's $1 million contract, you can't put a $5,000 liquidated. That's just not reasonable. But if they pay you $1,000 a month or $500 a month, and you say, hey, the greater of $5,000 or 6 months, that's totally reasonable. So now I can say, look, here's your $5,000 because you think I breached the agreement. I'm going away. Leave me alone. So it's a worst case scenario, but it's a contractual way to limit your exposure. So then the last item in a form agreement is sort of assumption of risk, and this can be risk for damage to equipment or corruption of data. You know, if a customer has a database that's got their whole business depends on it, if that data gets corrupted and you can't recover it, should you be responsible for it? Probably not. Reality, if they want you to, take that kind of investment in their IT systems, then you can talk about it. But you need to think about what risk is appropriate. An additional one is remote management tools.
Yeah.
IT professionals are, the RMM tools in the marketplace. You guys rely on those. Should you be responsible for the tools you're using if you're using them consistent with the way the vendor delivers them? I would think not. You don't make enough money to be on the hook for an RMM vendor's tool. So, but you're relying on that to deliver economical services to your clients. So those are some other things that are should you be on the hook for Office 365 failure or AWS access or the ISP internet access?
Yep.
There are different ways to kind of address that. But you got to remember that the statement of work is where you have the opportunity to ferret out those unique needs of every client. The definition of work you have to do, the deviations from your standard agreement, and your more specific responsibilities. That particularly comes into play when a third party may be involved, such as a medical records firm or some other technical service or a VoIP system. Let's say you guys sell a VoIP service. You don't know if the VoIP traffic's encrypted or not. Ever think about that? You know how hard it is to intercept data packets? It's easy, right? So there's a lot of stuff outside of your visibility and control. Moving to the next topic is the regulation traps. And really, again, it's go in with your eyes wide open. These traps are out there. You've got to know what you're walking into. They're very specific, whether it's electronic healthcare records, payment card data, attorney-client privilege. Those types of information are very clear. So understand, track the data, and map the data requirements to the creation, the storage, the transmission of that data. And you've got to run that through the system. The scenario that's a trap is you're doing that network management for the doctor's office remotely. Well, guess what? You're the business associate, and you are subject to HIPAA. Guess what? The HIPAA business associate claim is the basis for the implied duty for all scripts to secure the data, the electronic healthcare data that they have for those doctors' offices. So that extrapolation is real. And so you've got to understand that if you're going to operate in that world, are you a business associate or are you not? And decide. And if you are, you need to manage accordingly.
And
so
if you don't mind, let me just connect a dot here for the audience. Folks, if you go up to our YouTube channel, SMB Nation, that's 2 words, SMB Nation up on YouTube, you will find Mike Simmel's HIPAA lecture from earlier this year. So Mr. HIPAA, in terms of a book he wrote and so on, great resource, 90-minute webinar. Please continue, Ben.
Yeah, no, HIPAA is a great opportunity, and the risk is that I'm going to scare IT professionals away from serving that market. And frankly, of all the regulatory frameworks, HIPAA and getting smart on HIPAA, getting formed, you can't ignore it if you want to stay in IT. The regulations are coming, and so the healthcare providers take that for real. And it's an opportunity. They need your help. And even, if you know one man psychiatrist or psychologist practices, the natural medicine guy, he's subject to HIPAA. He doesn't want to think he is, but he is. And you can help him. Now, if he doesn't want to acknowledge it, you should run. But it's a great opportunity to get smart on those requirements and then help design a way to deliver your services where you match those requirements and help them meet them as well. So for instance, if you're going to do remote management of a HIPAA client, then you're a business associate and your infrastructure from which you do your remote management needs to be covered. That means you need to isolate it, you need to update it, you need to maintain it, you need to have policies and procedures, and you need to only use it for that purpose. So once you go down that path of creating that dedicated environment to do it, it's pretty easy, but it takes that allocation of resource. In addition, you've got to clearly document your responsibilities for covered systems and then what are covered systems, and ensure that your form agreement matches those requirements. So I think we've got another sponsor, Solar Winds, who's really been, I think, a great MSP partner. And you've got some information to share, Harry, about these guys?
I do. And so Solar Winds has been working with the SMB Nation community for since the beginning of the year, and actually some time ago, but specifically this year. Jenny, tee up the video, folks. You'll need to listen to the video on your computer speakers, and we'll see you on the other side. Thank you, Jenny.
Hello everyone, welcome to our first release video for N-Central, filmed right here in Ottawa in front of our beloved Parliament buildings. You should come visit sometime, but not in the winter, it's really too cold here. I'm Omar Cahill, Product Marketing Manager for N-Central, and with me is Chris Reed, Product Manager for N-Central. And we're here to tell you about how you can see more, know more, and do more with both N-Central 11.2 and 12.0. Let's start with how you can see more. Take it away, Chris.
Thanks, Omar. How many times have you had one of your end users call you and say, I can't access Office 365, or when I go to this website, it seems really slow? NetPath is a great way to understand where that problem may be occurring. Is it, for example, a problem with the local LAN that the customer's in, or is it a problem with a hop or a node somewhere along the way out in the public infrastructure? NetPath lets you understand where the problem may lie, and even better, if it's a public node, tells you who owns it and how to contact them. NetPath lets you map from any source server or workstation that you manage by showing you the path it would take to reach any destination IP address or hostname. The primary use case here is to map your customer's connectivity to popular cloud applications such as Office 365, G Suite, Amazon Web Services, or any networked application that's part of their business. NetPath reveals each hop, node, and link it would take for you to reach the destination, making it easy to troubleshoot hotspots or bottlenecks throughout the whole path. Not only can you see within your own network, but the ISP and cloud provider's infrastructure will be displayed to you within the NetPath window. When a problem does occur, NetPath gives you the contact email address and phone number for wherever the problem is occurring, so that you can more easily reach out to whoever owns that infrastructure and help them troubleshoot the problem. I can keep going, but check it out for yourself in the N-Central UI under the View NetPath menu. Click to add a path by selecting a server or workstation, typing in a destination, and within a few minutes, you'll have a path monitored within N-Central. The data is stored historically for 30 days, so you can even go back in time to troubleshoot any issues. Get started now by upgrading your N-Central server to version 12.0. Once the upgrade is complete, you'll have 5 free paths to use for 30 days. Give it a try today. We left some common URLs in the description below.
We're back. While Ginny brings up a poll, I'll do a little bit of housekeeping. Folks, it's 1 p.m. Pacific, 4 p.m. on the East Coast. You'll see in the background that I'm coming to you live from Microsoft Ignite. 30,000 people can't be wrong. Next week, I'm at GeekWire and Smartsheet in Seattle. The following week is in Austin, Texas for Spice World by Spiceworks. And I'll keep you posted. We got an Ingram conference coming up in DC in the month, and onward and upward. So I'll keep you posted. But I always look forward to seeing people as I'm able. I'll knock out a couple of questions that I can answer, and then I'm still going to hold off on the long one from Luis till a little bit later. A lot to unpack, but we have. Can we get a copy of the slides, please, when done? Ben, I believe that's your intent, is to prepare a PDF or make the slides available. That's my understanding.
Yeah, look out for the communication from Ginny and Adam. They'll tell you how to get them for sure.
Okay, great. And then we have another individual using a fictitious name, which I like. But the individual says, can you give us clauses that protect us and discuss them? And Ben, this was asked some time ago. I mean, I think that's kind of what you're doing as much as you're able. You're actually doing that.
Yeah, I think, I do appreciate the question. And I mean, it's like, oh, gee, Ben, you've told us about all these problems. Now, how the hell do we fix it? And I empathize with you because there may be some managed service documents out there that are worth using. I had done one some years ago, and so this is not the forum for me to do that. If you've got one, I think if a good place sometime to look. So lawyers use documents, and we call them forms. We hate to create something from scratch. So if you go find any service agreement from a highly reputable technology company, a big one, okay, maybe all scripts now if they've been sued, just pull it down and look at that, and then tailor it to your scenario. You'll find these sections that I mentioned in all of those good documents, and there'll be more there. So, but I kind of have to shy away from practicing law on this. So,
amen, brother. Hey, Jenny, go ahead and close out the poll. Give the controls back to Ben. And folks, got about just under 30 minutes. We're going to bring this in for a landing, and thank you, SolarWinds. So, Ben, you're back on.
Awesome. I do empathize very much with you guys, though, in terms of how to solve the problem. And I think a good contract is one answer, and I think that's the starting point. It doesn't beat a good relationship with your client, and it doesn't beat continued education and maintaining that relationship. And then the other is looking out for cyber insurance. Cyber insurance has absolutely exploded. The number of people chasing that industry. I mean, I'm getting letters from brokers that are trying to sell me cyber coverage. And it's like, where's it coming from? It's coming from my existing broker who's trying to attach a cyber policy to my current policy. It's coming from another broker that's telling me he's got all these other services to offer. And so, what is it? It's intended to offset the risk of cost related to a cyber incident. Guess what? It doesn't offset the responsibilities of doing good cyber hygiene. You have auto insurance, but you still have to drive reasonably carefully. In some states, if you're contributorily negligent in a matter, you may be liable. You don't have to be 100% responsible, but if you're partially responsible, you can't recover in a negligence claim. So remember, cyber insurance doesn't take you off the hook. It may provide a financial resource and access to experts. So it is growing popular. They are pursuing small businesses. It is very confusing. It's very dangerous because there are no standard policies. The FTC has done a report on 2 states, and they reviewed in a draft document that I found over 100 policies. They're none the same. They have applications that are very complex, many pages, ask many questions. guess what? Those applications become a part of your policy. If you lie, or if your customer lies on a policy, it can be used against them to prevent recovery of a loss. So if you think about it, when you got life insurance, if you smoke and you say you're a non-smoker, they're very specific framework, but that can void your life insurance policy. So if you have an application that says, do you use multi-factor authentication? Do you update? Do you have a firewall? Do you have an updated firewall? Do you segment your PCI data? You know, if you say yes and you don't, well, that's a misrepresentation. That may void your coverage, or your client may inadvertently void the coverage. That's really important to understand the application process. Additionally, the limits. In general, most professionals see a huge mismatch between the amount of coverage, the resources available, and the limits. You know, think of Target. They had, 10 million, or I don't know the exact number, and they had hundreds of millions of exposure.
Yeah.
Additionally, insurers use what are called exclusions to exclude items from coverage. So they'll say, hey, we cover a cyber incident for X, but not if A, B, C, D, E, F, G, H, I, J, K, right? And what happens is, in insurance policies, they evolve. In the world of environmental litigation and environmental coverage, when environmental policies started getting written in the 80s, people started trying to grab that business. They'd write a policy. Well, then they'd get sued, as the insurer to determine if they had to pay out. And somebody makes a claim, and the insurer says, oh, we don't have to pay. So the insured, the guy that paid the premium, sues them to say you got to pay. And then guess what? They use that example to go write an exclusion. So, well, we may have to pay this once, but we're never going to have to pay on this one again because we didn't contemplate that. So they exclusions expand and they get added over time. And one of the reasons is I heard a cybermetrics professor / author, he said there's not a Florida in the world of cybersecurity, meaning you can't predict hurricanes, cyber incidents the same way you can predict hurricanes, or the same way you can predict mortality, or the same way you can predict automobile accidents based on age, type of car, and where they drive, right? Those actuarial metrics are what make insurance a viable business approach. So without that, people are trying to write this coverage in a world where it's not real clear. In addition, you've got commissioned brokers who may be well educated and really smart, but we're talking about a very new product, a very technical product, a very legal driven product. And so they're grossly underexperienced, especially in the small business matter.
Well, and then I'm going to try to add value. I'm going to grab what you're throwing there. So again, here I am at Microsoft Ignite, and one of the pillars of the conversation, the conference, is analytics. Microsoft, right? They have IoT, they have Azure, they have analytics. They have, let's say, half a dozen pillars to message at this conference. And I've said in the past, and I'll say it again, that with respect to predictive analytics, which is where that would fit into IT, in your last conversation about being able to predict failure, being able to predict attacks. Ben, we're really, really early. We're at the 5 1/4 inch floppy disk stage. Here's the good news with analytics is this sucker's going to be a 10-year run. Okay, we're just really early, and I think I'm dovetailing to your conversation about cyber insurance, right?
I think that's right. But a lot of it is creating data and understanding in a contextualized world. Right. And when you do, I can explain that by when I'm looking for a gas station or a restaurant, I don't do it in Google. I I do it on a map search tool, right? I'm trying to say, give me a restaurant in this area. So likewise, I look at it as what's the risk if Calyptics provided you a LAN lockdown subnet for your PCI data environment that only communicates with your card processor, right? We're pretty confident we can lock that down because we can see any attempt to connect into the subnet or out of the subnet that doesn't meet that very rigid parameter. So on the restricted environment, that context, you can really control your risk. Meanwhile, on the wide open network, the untrusted network, the guest wireless, where you allow, where you don't put electronic health records, you're okay because that's also walled off. Now, if you screw it up and you don't check all the boxes to, segregate that LAN, that may be a misconfiguration. That's a problem. But if you've done it right, you can segregate that so you can reduce your risk. But it's really that middle zone that where businesses attempt to operate with confidential information. Is it restricted? Is it not? That gray area. And lawyers live in that world. They want to run their email with their intellectual property of their client, the Coke formula. They want to put it all on the same subnet. Well, you can't do that. I mean, you just, and in that area, you can't manage the risk accordingly. And so, but that's, I don't know if that helps. From an analytics perspective, when you have the analytics on those different environments, it becomes very valuable. But when you throw it all in the same pot, it's very difficult. And I think that's the world we're in today.
Yeah, and again, don't tell anyone. This is just between me and you, but we don't have the analytics yet, man. We're still developing this.
That's right. Yeah, well, that's right. I mean, we're building a way to collect the analytics securely and protect privacy. I mean, that's got to start first, right? You get and figure out how to get the right data. So then so you start looking at the cyber terms. So not only is sort of the framework of cyber coverage a challenge, it's also when you get into the weeds and look at the terms and provisions, it's extremely difficult. What losses are covered? What type of data is covered? First party losses are losses that the insured experiences. So when you get hit with a problem, and I've been paying premiums as a lawyer, as a law firm, are you going to cover the forensic expert, the legal defense expert, the pay to notify the victims, the notification for financial monitoring? That's a huge issue. That's not assumed because that's not a real loss. That's trying to mitigate a loss. Fines for regulators, insider events. Is it going to cover third-party vendor like the Allscripts breach? Is it going to cover, the actual data loss, like loss of access to the data, or is it going to cover only data theft? Somebody took the data. Those are two different cyber issues. Yeah. And so what losses are covered, it's not so clear. And so that gets really complicated. And then what are the limits? Do they limit by type of loss? Do they limit when the event occurred? So some policies will say, hey, we're not going to cover a breach if the breach started before you got the coverage, right? So if you don't know the breach happened, and most people don't know when it starts, so then the insurer can say, well, it started before you started paying us premiums, so we're not responsible. So that's another really complicated issue. But, another way it can become your problem is that the benefits that are there may be conditioned on specific requirements. An annual audit, an update of a questionnaire, a network implementation framework that you have to confirm. Those reps and warranties that I talked about that might be in the application. And if that conditions your coverage, you could be in real trouble if you weren't party to your customers, signing off on them. And then there's another risk that's a very technical legal risk that I don't want to scare everybody about it, but in a lot of insurance policies, there's a concept called subrogation. So if Harry's the insurer and he's going to underwrite my risk and I pay him premiums. If I experience a loss, a subrogation right contractually allows him to step in my shoes to recover against any third party that may have been responsible for those losses. So how does that happen? So in an automobile accident, if I have an accident and it was somebody else's fault, well, he may pay off the claims and make me good, but then he's going to go step in my shoes and sue the other person to get the money back. Likewise, if they think it's the IT provider's fault or the software vendor's fault or the ISP's fault, they may be able to step in the shoes of the victim and recover some of those proceeds. So really, we're in its infancy, but that subrogation right is the way some of this litigation may evolve, because you then get a sophisticated party, an insurer that's a repeat litigator, going after vendors that are not maintaining their code, that are writing sloppy code, that are allowing problems. They could be a source of those claims. But that's speculation on my part. It's just, but that is a risk, in terms of how that's out there. That's, again, you go back to that rock solid contract, a good client relationship, and transparency. And then really, this was Adam's, perspective as he started. We were talking about cyber policies. He said, it's almost like another set of regulations. If your customer has cyber insurance, then what are the requirements for him to actually get the benefits? So you need to know if your client has cyber coverage, whether you sold it to them or not, whether you were part of it, because if there are requirements there, you need to help them meet them. And if they don't want to help you meet them, then they need to tell you that. So that's a huge thing to ask is do they have coverage? It is valuable. You got to know whose responsibilities, and really, you need to be part of the process of reviewing the coverage, of purchasing the coverage, of maintaining the coverage, evaluating it annually. Is it the right kind of coverage? Are the right kind of losses covered? Are the right amounts covered? You don't have to be an expert there, but you can guarantee that your small business client does not have a lawyer that's an expert in cyber coverage, and he's not an expert in IT. So you can help in a collaborative way by bringing the right knowledge bearers to the table to have a good, healthy conversation about what makes sense. And quite candidly, if you go in with the idea, I don't know the answers, we got to figure this out, I'm not charging you for it because it's relevant for all my clients, and you do that a couple of times, you'll get pretty savvy pretty quick, because they all want to be on the same forums for efficiency. So, you'll start to pick up the differences. But so that's let me share a little bit about what we do at Calyptix, Harry, and I appreciate the opportunity to speak today. And,
Sure.
What do we do?
And
how we're different.
Yeah, and Ben, just before we do that, and absolutely, Jenny, I don't know if you could copy and paste into chat the longer question earlier from Luis Swall to Ben. Ben, on your control panel, you have a chat feature.
Oh, yeah, that'd be great. Well, while she's doing this, I'll do the
Yeah.
But essentially, we provide a UTM to small businesses. We are small business focused. I mean, it's a very comprehensive, multifaceted, easy to use. We started, it was like, how do we help small IT professionals that, provide gateway security and make it easy. I used to use a theory, dumb it down to Ben. It's got to be, easy. And one of the most important things we've been doing from day one is automatic updates. What does that mean? That means we update it continuously with new, security updates, bad domains, bad IPs, bad IDS, IPS rules, those types of things. If you use the email filtering, email rules, and then more sort of iterative updates around the firmware. They may be patches, they may be enhancements, they may be bugs. I mean, we updated our boxes to go from 1024 crypto to 4096 crypto. Nobody knew it, and it happened overnight. And we updated from SSL 3.0 to TLS 1.0 to 1.1 to whatever it is now, because that's what we do, and so we understand that most of the MSPs we work with focus on server side, client side, line of business. They're not command line Linux network gurus. So we do that updating, and we make that easy to take that PCI gateway compliance issue, and we make it really easy. We do other things to make it easy, like providing configurations, logistics, things like that. So for instance, we provide a config guideline. If you answer a couple of questions, we'll give you the config that you need. We'll ship replacement boxes with your customer config on it to their site, things like that. It's we focus on a service relationship. Our support is phenomenal. And why is it? Because you get access to US-based high-level techs that don't say, hey, it's not my problem, and they're reading a script. I mean, we want to help solve your problem. We do the training. So we do, it's very flexible program. If you want to learn more, reach out to us. We're not going to hammer you. But we'd love to work with you. Managed services is delivering secure systems to your clients. It's a utility service. If you're not doing it, do it. If you're doing it, do it right. You got a great business opportunity, and keep working with it. So we also have a handout that if you email Rachel, she will send you a legal questionnaire to help smoke out the issues tailored to each client in a thoughtful way, regulations, backup, any unique questions. It's a really good, whether you incorporate it into your statement of work or you use the questionnaire outright, it's a good starting point. So with that, we got the questions, and let me jump. Okay. So let me.
All right. And do you have that question in chat, Ben? You got to.
I do. I'm reading it now. So.
Ben, while you're doing that, folks, totally appreciate your participation again. Next week in Seattle at Smart Sheet and GeekWire. The following week, Austin, Texas at Spice World. An Ingram conference in DC in the month. I'll stay in touch with you. Love to get together with some people out here. Ben, back to you.
So the question is, how do we handle clients that don't want to pay us, that basically use internal staff to make changes, and then they blame us for the problems, not securing the system? What's the best way to handle that? And so really, that would go to an exclusion, in my opinion. So this is, if the customer is going to have admin access to their infrastructure and their systems, then you can write an express exclusion. In no way, shape, or form shall we be liable for any damages that result directly or indirectly from third-party solutions, your internal staff making changes, using the systems in a way that it's not supposed to, operating, managing, or doing things, without our awareness, knowledge, or guidance. And so then if they do something, that fits that bill, they have a user admin, a domain admin, and they start surfing the web, and they look at bad sites, and that causes the network to be compromised, and then that's clearly their responsibility. Now I go back to that dynamic of relying on the document versus not having to go to the document. So you can write that document where you would be protected, I think, reasonably, but it's still going to create a relationship problem. If the understanding is that you're going to allow somebody to make changes, then you can't provide assurance. So there's the legal exposure, there's the economic exposure, and then there's the relationship exposure, I think. So I think I've addressed the legal by putting a provision in that says you're not responsible for it. From a financial, as a business owner, as an MSP that's providing a fixed fee to manage the network, if their staff can make changes to the network, then I want to know what those changes are so that I can properly price my monthly services. So if there's, hey, maybe they're going to add some domains to the whitelist. Maybe they're going to add, some whatever, some things that may make sense in that context. Then you're going to say, these are okay, and that's included in my MSP fee. But anything other than that, not only am I not responsible for, if I have to deal with it, I'm going to charge you a premium to come back and deal with it over top of the fee. And
hey,
so,
Dan,
yeah.
Yeah, while you're talking, go back to Rachel's email address. Steve Paul wanted to.
Sorry about that. So it's rachel.hawkins@calyptics.com. And so what that is it's a series of questions that would be, you deliver in advance of preparing a statement of work. And you may combine these with your own, sort of questionnaire or service offering that you can, help itemize. Because you need to know your role, and it helps smoke out if there are other players in the network, if you will. If there's Allscripts that's responsible for the electronic healthcare records subnet and so forth.
And Jenny, if you could be so kind as to put that in the thank you letter tomorrow with the replay link. Ben, I believe we're at time. So thank you, sir. And thank you for being, my goodness gracious, over 10 years in the community. Boy, man, we were there on the beaches of Normandy, as they say.
Well, Harry, I think so. And I think the opportunity for the community of SMB Nation to be really active in cybersecurity it couldn't be greater. I was reading that there's some 200,000 open cybersecurity positions today. It's growing at like an unprecedented rate, and our clients are all investing a lot of money. They're risking their business depending on technology, and if it's not secured and delivered and managed, and to make sure it works, that make sure the information is secure, the systems are available to the right people at the right time. I mean, it's all for naught, and they're at risk. And the reason we don't see small business cyber breaches in the news is because they go away. You see the litigation over Target because Target does billions of dollars worth of, credit card fees a year. They're too big to fail. So they're going to litigate it. But if my doctor, who's a small doctor's office, has a breach, they're going to just crush him. And so he goes away. So they need our help. They need MSP's help, and there's huge need and opportunity. So I appreciate the opportunity.
All right. Well, we'll make that the final word, folks. Thank you very much. We'll be back next week with a deep dive into the popular and revised email program from Constant Contact. Stand by. They're doing more than you think. Thank you for attending. Have a great week. We'll see you next week. Thank you, Jenny. Thank you, Ben.
Thank you, guys. Bye-bye.